We'll call the committee meeting on public safety and security policy and finance to order. We will start with the roll call.
Johnson.
Here.
Lomer.
Here.
Hillstrom.
Here.
Beckerfin.
Here.
Considine.
Here.
Dean.
Here.
Frankie.
Here.
Grossel.
Here.
Howe. Lucero. Newberger. O'Neill.
Here.
Pinto.
Here.
Uglum. Ward.
Here.
Zerwas.
We have the minutes in front of you. Has anybody had an opportunity to go through them? And
I would move the minutes, Mr. Chair.
Representative Hillstrom moved to approve. All those in favor say aye.
Aye.
Opposed? Okay, this morning, we're going to hear from the Commission on Juvenile Sentencing and Heinous Crimes, go through their report. We'll have, starting out with John Kingery and Judge Kathleen Guerin. Welcome to the committee. If you could introduce yourselves and go ahead and get started.
Mr. Chairman and members of the committee, my name is John Kingery. I was the co-chair of the State Bar Association Commission on Juvenile Sentencing for Heinous Crimes, which was established in December of 2016. Joining me and speaking in a few minutes is Judge Kathleen Guerin. We co-chaired the commission, which included 19 members, which I'll describe in just a couple of minutes. Again, this was created by the State Bar. It really was necessitated by several Supreme Court decisions, but two of the more important ones were Miller versus Alabama, which was decided in 2012, and Montgomery versus Louisiana, which prohibited mandatory life sentences without the possibility of release for homicides committed by juveniles. Those two decisions.
Excuse me, could you see if you can get close to the mic? We have them. I don't know if it's working or not.
Those two, is that better, Mr. Chairman?
No.
Those two decisions,
Representative Grossel, that a little better?
we got volume. Mr. Chairman, members of the committee, is that better?
That's
Okay,
better. Thank you.
Thank you. Again, the commission was necessitated by two Supreme Court decisions, Miller versus Alabama in 2012 and Montgomery versus Louisiana in 2016, which prohibited mandatory life sentences without the possibility of release for homicides committed by juveniles. Those two decisions rendered the Minnesota statute on heinous crimes unconstitutional. In those decisions and several others, the court said that the Eighth Amendment the Constitution prohibited cruel, unusual punishment and as a result forbade such sentencing schemes. The charge to the commission was to make recommendations to the legislature regarding the factors that should be used to sentence juveniles who are convicted under the Heinous Crimes Act. Should the legislature decide to maintain sentencing a juvenile to life without the possibility of release. It's the so-called Miller factors, which Judge Guerin will go into in a little bit more detail. And before you are the commission members. Included 19 individuals, judges, representatives from the legislature, Representative O'Neill and Representative Lesh served with distinction on the commission. Representative O'Neill has the distinction of making every meeting, all 7 of them, all 7 2.5-hour meetings, and we appreciated her input very much, and I thank her for attending. Also, Senator Hall and Senator Hayden were the legislative representatives on the commission. We had prosecutors, criminal defense attorney, and experts in community corrections, neuroscience, child psychology, and juvenile rehabilitation. As I indicated, we had 7 meetings and concluded in December of 2017. At each meeting, child psychology experts and key criminal justice stakeholders made presentations regarding this particular issue, and and the impact on juveniles. And the recommendations of the commission represent our best efforts to bring Minnesota into conformity with both Miller and Montgomery. And the need to correct this legislation, to correct our statute, is a priority by the Minnesota State Bar Association. With that, I'll let Judge Guerin discuss very quickly some of the key decisions that led us here and then go through the PowerPoint with you.
Okay. Thank you, Mr. Chairman and Senators, for letting us appear here. All of the people on this committee, it was a volunteer kind of recruited by Robin Wolpert, who was the former president of the Bar Association. This was a project she took on and recruited us. A little arm twisting, too, was connected with it. And it was composed, the committee, we wanted to get all aspects, the chief public defender, a county attorney person, experts in probation, sentencing, victim impact people. We got a variety of people to be on this, so we would get a lot of information from all types of people. It was triggered by the fact that Minnesota has a statute that requires mandatory life sentence without possibility of parole that includes juveniles. The United States Supreme Court in Miller v. Alabama. Well, before I go further, I should introduce myself further. As a lot of you probably know me, I recognize Senator Pinto there. I was an assistant county attorney in Ramsey County for years. Then I was a sitting trial court judge in Ramsey County for a little over 26 years. I'm now what's called a senior judge. I'm retired, and this committee is proof, as some people have said, I'm partially flunking retirement, but I still sit occasionally as a senior judge, and did this as a volunteer, totally as a volunteer, not officially as a judge, but as a retired person with my background and experience. So with the Miller v. Alabama case, which was in 2012, the Supreme Court ruled that the Eighth Amendment, that it would be cruel and unusual punishment to sentence a juvenile to prison without the possibility of release. They kept it to juvenile homicide offenders is what that case had to deal with. They said it was a little bit like, they didn't say you could never sentence a juvenile to life without parole. They said it is excessive under the Eighth Amendment for all but the rare juvenile offender whose crime reflects, get this phrase, how do you define this? Irreparable corruption. But that was one of the things that we were doing, because ultimately our recommendation is going to be that you need to do something, but the choice is yours because you are the policymakers. And you can either do away totally with the possibility in Minnesota of sentencing a juvenile offender to life in prison without any possibility of parole, or if your policy choice is to keep that as an option, you have to set up some type of procedure or criteria that deal with the issue of whether this juvenile is irreparably corrupted. Again, Miller doesn't ban it, but they say it's a very exceptional circumstance. They said also that if a court decided to sentence without possibility of parole, they needed to consider the offender's youth and attendant characteristics and circumstances. In Minnesota, as I said, the Heinous Crimes Act, 609.106, provides that certain crimes, including first-degree premeditated murder, shall, not may, but shall be sentenced to life without the possibility of release. On its face, the statute is unconstitutional as regards juveniles, only juveniles. We are proposing two options. One, as you say, amend it to specify the factors that should be used to sentence juveniles who are convicted of crimes under the Heinous Crimes Act. So, for example, premeditated first-degree murder. Or two, eliminate the sentence of life without the possibility of release for juveniles who are convicted under the Act and establish a sentence of life in prison with the eligibility for parole after a specific term of years. Again, we don't recommend, if that's such option you choose, what the specific number of years should be. Again, we feel that's a policy decision that legislatures should make. Then the committee really spent most of our time dealing with what the factors should be. And to do this, we read the case law because, the United States Supreme Court has chewed this issue around in a number of cases, starting with Miller, actually starting with a case called Roper, which was earlier, where they said the death penalty for juveniles is out the door. You can't do that because juveniles are different from adults. And I think that's a concept we can all, accept. The factors for option one, if that's the option you choose to keep. From the case law, it must be determined whether the juvenile is one of the rare offenders whose crime reflects irreparable corruption or permanent incorrigibility, or whether the juvenile is one whose crime reflects transient immaturity. Okay, the language is right from the case law. And really, when you stop and think about it, as all of our committee meetings, we realize those are pretty complicated, but actually wise terminology for what our common sense tells us about juveniles. They are immature, but is it transient immaturity? Is it irreparable corruption? How do we determine that? What criteria should be set up for, if in fact you keep that option, for a judge to look at as on option one? This is what our discussion centered on. If you read the report, we brought in all kinds of people. At one point, we were hoping that a neuroscientist could give us something that, concrete that we could look at. And we brought in Dr. Francis Chen, probably one of the leading neuroscientists on adolescent issues in the country, from the University of Minnesota. And we were disappointed. There isn't a magic bullet. Neuroscience hasn't, psychiatry, we haven't gotten to a point where we can predict with any surety if somebody is irreparably corrupted or transiently immature. So then we looked at the case law, the wisdom of the United States Supreme Court. We also looked at Minnesota's history of what factors have been considered in similar circumstances when dealing with juveniles, such as deciding when a juvenile should be certified before we had the mandatory certified, which means trial as an adult. Those types of factors, we feel that reflects the Minnesota history, and also our sentencing guidelines and what factors are considered by judges and have been for years in determining when you depart from the regular sentence and sentence heavier or lighter. So these are the factors that we believe you should put in the statute if option one is your choice. The nature and circumstances of the offense committed by the defendant, including any mitigating and/or aggravating facts. I guess some murders are different from other murders, like one way of putting it. The defendant's age and intellectual capacity at the time of offense. The extent of the defendant's participation in the offense. Were they the planner, the leader, the follower, the aider and abetter? The effect, if any, of familial pressure or peer pressure on the defendant's actions at the time of the offense. The defendant's immaturity, impetuosity, or failure to appreciate risks and consequences at the time of the offense. The defendant's mental, emotional, and psychological health. The defendant's background, including his or her family, home, and community environment. The nature and extent of the defendant's prior delinquent and/or criminal history. Most of them have delinquent history. Some juvenile murders don't have any criminal history at all. Some may have been previously, even though they're still a juvenile, they may have been previously tried as an adult, so they have an adult history. And the defendant's prior history of delinquency programming and treatment, and any other circumstances relevant to the determination of irreparable corruption or transient immaturity. That last factor is a catch-all, that usually the legislature has put into statutes that relate to this at all, because we don't know in future, for example, whether neuroscience will be able to give us more information. And that leaves the door open for other information that may be relevant to those 2 points. Then another factor that we add to, if you decide to keep option 1, is to make part of the statute, the sentencing judge must order a psychological evaluation or a psychiatric evaluation by a licensed professional with expertise in forensic evaluations of juveniles. This is usually done anyhow, but this makes it a must. And given our discussions, given the case law in which the Supreme Court has discussed these issues, the United States Supreme Court, we believe that that should be part of your decision. I think that takes care of what I had to say. One thing somebody asked, I'm going to anticipate a question. Somebody said, well, why don't we just let the courts deal with it? Well, because I think it's the opinion of the whole committee and mine personally, this is a policy decision. Judges shouldn't be doing public policy. That's your job. We don't like to do it. We don't want to do it. Okay? Thank you.
We'll be followed by Kelly Mitchell, the Executive Director of the Robina Institute and also a commission member.
Welcome. If you could please state your name for the record and go ahead and proceed.
Thank you, Mr. Chairman. I am Kelly Mitchell. I'm Executive Director of the Robina Institute of Criminal Law and Criminal Justice. Previously, I served as the Director of the Minnesota Sentencing Guidelines Commission, and I also was asked to serve on the committee with the rest of the members. And one of the key things that I was able to bring to this discussion is what are other states doing to address the same issue. This is a U.S. Supreme Court case. We're not unique. Every state had life without parole sentences that were applicable to juvenile offenders. So how have the other states dealt with it? And that's what I'm going to talk about today. So when the commission first began meeting in 2017, there were 11 states that had not yet addressed their laws to bring them into conformity with the Supreme Court decisions. These are the 11 states that hadn't acted as of that time. And this is a shifting sand. The sands are shifting quickly underneath this issue. So just in the time from when we began to meet to today, 3 more states have addressed their laws. So now we're one of 8 states that have not yet attempted to deal with this issue. So what are the options? There's basically 3 directions that the states have gone. The first option is to eliminate life without parole sentence for juveniles and basically replace that with a sentence of life. So you can still have a mandatory sentence, but have it be life instead of life without parole, and then set a term of years for when the juvenile might be eligible for first consideration for parole. So that's one direction that states have gone. The other direction that states have gone is to retain discretionary life without parole, which means that you have a choice before the court of whether the sentence should be life or life without release. But in order to make that determination, then the court has to have those factors built into the law so that they can have the appropriate information upon which to make that decision. And that's really what the case is, what the case calls for, what Miller calls for. And then the third direction that states have gone is to institute some other form of discretionary life without parole. And the most common way of doing this has been to have the parole board establish new time periods for consideration, even if the person was given life without parole, giving the parole board the authority to have a hearing to determine whether the individual could be eligible for release. And so that's the one option that's not available to us because we are a determinate state and we don't have parole in our system. So this is the status of the laws today. The dark blue states are those that have chosen to eliminate parole, institute a sentence of life, and set a term of years for first consideration for release. The next lightest color are those that have changed their laws to include the Miller factors. The very lightest blue are those that have discretionary parole in some other form. So that's usually the parole board is taking control of that decision. And then the gray states, again, are the ones that haven't yet done anything to address their laws. And I will say that most of these states that are in gray are like us and have very few offenses that life without parole sentences apply to. So there hasn't been as much urgency there. This is the tally, just to make it easy for you to get the read. So going with the life sentence it has been the more popular choice among the states, with 21 states and the District of Columbia going with that route. 8 states have changed their laws to include the Miller factors. 13 have dealt with it in another way, the kind of option that's not available to us. And then there's the 8 that haven't done anything. I do want to make sure that we are focused in on the fact that there's really 2 cases that we need to be concerned about in Minnesota, and 2 statutes that we need to be concerned about. I'll talk about the premeditated murder statute in a moment, but the other statute that has been impacted is 609.3455, and that's a statute that provides the penalty for certain egregious first-time or repeat sex offenses. It's very rarely used against anyone, let alone a juvenile, but it's a non-homicide offense. And so the other Supreme Court case that is important to understand is Graham v. Florida. That came out right before Miller, and that categorically determined that categorically life without parole sentences cannot be given to juveniles for non-homicide offenses. So the only choice we have to bring that statute into conformity with the Constitution is to amend it to a life sentence. So that's the only way you can go with that one. As Judge Gearin mentioned, for the 609.106 first-degree murder statute, we have 2 options. We could retain life without parole as long as we build those factors in, or we could change that to a life sentence with a term of years for first consideration of release. Just to recap, Judge Gearin already went through the process that we did to arrive at the Miller factors. Here's the actual language from the statute. If you want to compare, there's really like one compact paragraph in Miller that sets forth the considerations that the court should make when determining whether life without parole is appropriate for juveniles. This is the key language. So this is where we started. We looked at all the other statutes for the other states that had actually incorporated those laws into their, incorporated the factors into their laws. We have a chart within the report that we've provided to you that actually tells you state by state which factors they've brought in. But the long and the short of it is that pretty much everyone brought in all of the Miller factors except for the one that says inability to deal with police officers or prosecutors. That was really squishy language that didn't make, it was really hard to determine how you would operationalize that. So none of the 12 states really brought that language in, but they brought in all the rest of it. And then the 12 states that have included those factors brought in a few other ideas like intellectual capacity, criminal history, and you'll see that we built those into the recommended factors as well. The last thing that I would like to point out is that there is an unresolved Blakely issue, and that's also been highlighted for you in the report. Blakely was a case that happened even before Miller and Graham in 2004, and if for any of you who were here in 2004 when that happened, you know that we needed to adjust a lot of our statutes in order to bring them into compliance and make sure that our sentencing guidelines continue to work under Blakely. And what that case said is that any fact other than a fact of a prior conviction that increases the penalty beyond the statutory maximum must be submitted to a jury and proven beyond a reasonable doubt. So there was actually a question among the committee members as to whether Blakely would apply to this issue and apply to how we could fix the statute. it's an open question. We disagreed, and we didn't have enough time to resolve it, so I'm hoping that your attorneys will take a good look at this issue. But the questions that really are out there is, would Blakely, if we were to set up the statute to provide that choice between life and life without parole, would Blakely require that all of the factors that are built into the statute be submitted to a jury in order to be proven? Or is it possible to structure that statute in a way that it wouldn't be necessary, that it would be the court's purview to review that information rather than it needing to be proven to a jury? So that is really an open question, and how you evaluate that may determine the road that you're interested in taking in order to bring the statute into compliance with the U.S. Supreme Court cases. And that's all I have. And I think, go ahead.
Kelly is going to be followed by another commission member, Professor Perry Moriarty. Professor Moriarty has extensive experience in this area and has been asked and was very helpful in our deliberations at the commission. She'll be followed by Dakota County Attorney James Backstrom and retired Justice Paul Anderson.
Good morning. My name is Perry Moriarty. I'm an associate professor at the University of Minnesota Law School. I teach criminal law, juvenile justice, and I co-direct our child advocacy and juvenile justice clinic. Among other things, our clinic represents juveniles who have been charged with delinquency offenses in juvenile court, and we also represent individuals who were sentenced to life without parole in Minnesota as juveniles. So I'm going to go through a list of 8 individuals who have been sentenced to juvenile life without parole in this state. And I do want to be clear at the outset that our clinic does represent 2 of them. I'm here today primarily to provide an overview of these cases. But before I begin, I want to say a few words about the cases and the list I've provided. The list before you is intended to be a bare bones overview of the cases. It was written to be as neutral as possible, to provide the procedural history and the basic facts of these cases. But of course, these cases are a lot more than that. Each case has 1 or more victims who mattered immensely and who should not have died. And I want to be clear about that. Each of these victims had families, friends, and communities. And the commission, in its work, never lost sight of that fact. In fact, I believe I can speak for everyone on the commission when I say that nothing we propose, none of our work, is ever intended to discount the lives or experiences of victims or their families. In fact, several of our members have devoted their entire careers to vindicating the rights of victims. And I say that as someone who also defends those accused of killing these people. Of course, each of these cases also has a defendant. And each defendant was a child at the time of the offense. And in most cases, that child has a tragic story, or did have a tragic story when he or she was a child of their own. And again, I know this because I represent 2 of them and have spent a lot of time with them currently in their facilities. All 8 experienced poverty, some form of disrupted family. Many of them were exposed to violent victimization of their own. They suffered developmental delays and mental illnesses. All of the things that we understand plague an enormous number of our criminal defendants. So I want to say this, I can't emphasize it enough. The list you have does not bring fully to life these cases on either side. And the question really before us is, how do we deal with acts like these? How do we overcome the notion that some of these acts are in fact heinous, but they were committed by our children? And they were committed by children who, the question is, can we say, may or may not be fully formed. They may not be done. And I know several of you met last week with someone who was sentenced to a very long sentence as a 13-year-old. who came out the other end and is a pretty remarkable human being. So that's the backdrop, and now I will go through these cases. And I've listed them in chronological order, oldest to most recent. The first one involves Timothy Chambers, who was 17 years old when he was convicted of first-degree intentional homicide of a police officer and several related felonies. And this involved a 1996 incident he was involved in. I'll say up front, I represent him. He was involved in a police chase, and an officer who, by all accounts, was, acting bravely, set his car up as a barricade on an exit in a road in Rice County. And Mr. Chambers drove up the exit and into the barricade, and the officer was killed. And he was sentenced to life without parole in 1996. And pursuant to the Minnesota Supreme Court's 2016 decision in Jackson versus State, and I'll try not to go into this in too much detail, except to say the Minnesota Supreme Court decided that in old cases involving juveniles serving life without parole, that the court acknowledged had to be addressed under Miller and then subsequently under Montgomery. The question is, can you really go back and assess a juvenile's culpability, in this case, 20 years after the fact? Can you find all the facts that you need to? Can you consider all of the evidence that you should to fully assess culpability and capacity for rehabilitation at the time of the offense? And the Minnesota Supreme Court said no. The passage of time precludes that. So instead, it did something fairly tricky. It revived an old statute. It's a process called statutory revival. It revived the statute that was in effect the last time this particular statute was constitutional. And that statute mandated that a juvenile in the situation of most of the 8 individuals be sentenced to life with eligibility for release after 30 years. And that's embodied in a decision called Jackson versus State. So pursuant to Jackson, Mr. Chambers was resentenced in January, and he will be eligible for parole, I believe, in 2026. Eligible for release. I stand corrected. Mr. Roman Nose was convicted of first-degree premeditated homicide and first-degree intentional homicide while committing a sexual assault for the July 2000 sexual assault and stabbing death of a 17-year-old girl. He, too, was sentenced to life without release.
I believe Representative Considine has a question for you.
Thank you, Mr. Chair. He was resentenced to 30 years, the first gentleman. When does that 30 years start?
It begins the day that he was originally incarcerated. So in his case, and I believe in the case of all 8, they were brought into custody really immediately upon their arrest for the incident in question, and have never been released since. So that the clock starts running then. So with Timothy Chambers, it would be May 1996. I don't have the specific day. It'd be 30 years out from that point that eligibility would be triggered. And again, that doesn't equate with release. That is simply the first point at which he would be eligible to go before the appropriate authority and seek release.
Thank you.
Mr. Chair.
Thank you, Mr. Chair.
Representative Hillstrom?
Thank you, Mr. Chair. So who now is that appropriate authority that will be making the determination on whether or not he will be released after 30 years?
That is a terrific question, I'm Representative Hillstrom. That is something that the commission absolutely recognized as sort of an open question, to the extent that we believe that there should be some authority that can not just review cases as we typically have in Minnesota, but can do so with an appropriate awareness and knowledge of the so-called Miller factors. That is something that is still for, I believe, this body and the legislature to decide. I'll defer to Ms. Mitchell.
Please introduce yourself and then
Thank you. Kelly Mitchell, Executive Director of the Robina Institute. Currently, under the way that the statutes work right now, the releasing authority is the Commissioner of Corrections for anyone who is serving a life sentence. The Department of Corrections should be the one to answer how that process works, but I know that they have a review process and an evaluation process for all individuals who are eligible for consideration for release that they go through before he makes a determination.
Thank you. Representative Constantine?
Thank you, Mr. Chair. Currently, under most sentences, the last third is knocked off almost automatically. So are you saying that's different in this case?
It is. It's different in the case of life sentences where there is parole eligibility upon a date certain. That's the real distinction. And that is because a life sentence with eligibility for parole is not determined in the same way that the rest of our sentencing scheme is.
But we
Representative Constantine?
But we don't have a parole board, so that's not set up yet, so that's what you're saying, it's not been determined yet.
Technically, it is accounted for in the statute, as Ms. Mitchell just indicated. And I'm sorry, I should have responded to that piece first, Representative Hillstrom. Yes, we do have a mechanism in place that involves corrections reviewing all of these sentences as they come forward. It's not parole in the traditional sense that we've seen in other states because our state has a determinant sentencing process. The open question I know in other states that have our form of sentencing scheme is whether that particular review process that normally rests within corrections should somehow also be infused with some of these other factors that we've discussed, and that the composition of whatever committee is involved in doing that review be altered to account for the fact that these individuals have a somewhat different history. I hope that answers the question.
It does. It also would seem to put a tremendous burden on the Commissioner of Corrections at this point. Thank you, Mr. Chair.
Thank you.
Might I respond to that?
Yes, go
briefly?
ahead.
That is something that we have periodically discussed with Commissioner Roy, and certainly something that we all take very seriously. The really good news about Minnesota is that we don't have that many individuals in this situation. Other states, for example, Pennsylvania is working with over 500 individuals now. We have 8 who will be coming up, and the tradition here, of course, is that we don't seek extreme sentences nearly as often as other states. So what Commissioner Roy has said, at the very least privately, is that the numbers are such that they could be accommodated, but it is a very good question.
Thank you, Mr. Chair.
Go ahead and continue.
Okay. I'll continue to go through the cases. Oops, my apologies. Nope, I'm not trying to, okay. Here we go. What have I done here? Okay, I'll continue to go through the cases. I'll only provide detail beyond what's on the slide to the extent anyone on the committee seeks it. But Mr. Roman knows, like Mr. Chambers, also was resentenced pursuant to Jackson to life with release eligibility after 30 years, and that too would begin at the point of his original incarceration. Mr. Pendleton similarly was resentenced in the fall of 2016 to life with eligibility after 30 years. His case involved, as a 15-year-old, the first-degree premeditated homicide and first-degree intentional felony murder and kidnapping and stabbing death of an adult male near Morton, Minnesota. There were 3 adult accomplices involved in this particular case. And again, you begin the 30-year count starting in September 2004. Prentice Jackson is the case in which our Minnesota Supreme Court decided how to handle these retroactive Miller cases. And his case involved a gang-related shooting death of a 15-year-old boy. He was originally sentenced to life without release, and pursuant to the decision in his own case, resentenced in October 2016 to life with eligibility after 30 years. Lamonte Martin was involved in another gang-related shooting death, in this case of a 19-year-old man. He too was sentenced to life without release. He also received a new sentence of life with release eligibility after 30 years and a consecutive 12-month term to be tacked on to the end for a crime committed for the benefit of a gang. Brian Lee Flowers and Stephon Thompson, this chart should be updated because we received a sentence in Mr. Flowers' case about an hour ago that actually changes the contours of where we go from here. And I should, in full disclosure, I represent Mr. Flowers. Both Mr. Flowers and Mr. Thompson were convicted as co-defendants for several charges, including first-degree premeditated murder for the June 2008 stabbing death of a woman and her 10-year-old son. They were both originally sentenced to consecutive life without release terms, but as you might expect, because the sentences were automatic, there was not, in fact, a sentencing hearing. Those sentences were simply imposed automatically after the conviction. Both cases have been litigated extensively in federal court and state court. Mr. Flowers was resentenced to concurrent sentences of life with release eligibility after 30 years in March of 2007. The distinction, though, there was whether or not the decision in Jackson, which said that you cannot go back after the passage of time and recreate evidence that you don't have and assess culpability and capacity for rehabilitation, precluded the district court's ability to impose consecutive sentences, which of course does involve some measure of culpability assessment of its own. And the court said under Jackson it couldn't do that. The state appealed, and just this morning the Minnesota Supreme Court decided that in fact the district court can do that and remanded the case back to the district court for an evidentiary hearing during which it will go through the process of assessing culpability relative to the imposition of concurrent versus consecutive sentences. And I believe the same process will then take place in Mr. Thompson's case as well. The final case is the case of Mahdi Hassan Ali. In this case, he was convicted of several homicide-related offenses for the 2010 shooting deaths of 3 men during a robbery of the Seward Market. And this case has a complicated procedural history as well. He was originally sentenced to 2 consecutive life terms with release eligibility at 30 years and a single life without release term, which was automatic. His case, the appeal was not yet final. The sentence was not yet final at the time Miller came down. So his is not technically one of the retroactive Miller cases. The review of his sentence became automatic. The court did not need to wait to find out whether Miller applied retroactively. And what the court essentially did was the Minnesota Supreme Court affirmed on appeal the 2 consecutive life sentences with eligibility after 30 years, but then sent back the life without release sentence to the district court for resentencing. And at the time it said, go through the Miller factor process and when you're resentencing him. The district court judge said, well, instead, why don't I just impose a 3rd life with eligibility for release term after 30 years, which would amount to life with first eligibility for release after 90 years. That sentence was appealed. It was upheld by the Minnesota Supreme Court, and a petition for certiorari is currently pending. So that is the universe of the 8 cases, all of which have been resentenced to this point with the exception of Flowers and Thompson, and then Mr. Ali's sentence is currently potentially pending before the U.S. Supreme Court. I'd be happy to stand for questions.
Thank you.
Thank you.
Mr. Backstrom, if you could. introduce
Thank you.
yourself.
Good morning, Mr. Chair, members of the committee. I'm James Backstrom, the Dakota County Attorney. I'm also a member of the Board of Directors of the Minnesota County Attorneys Association. I was a member of this commission that reviewed these sentencing issues that you're hearing the report in reference to today. I fully support the report that was completed by the commission, and I support its recommendations. But I am here today to tell you what the position of the Minnesota County Attorneys Association is. You've heard that there's a number of options you can do in reference to addressing the unconstitutionality of this statute. The Minnesota County attorneys for a number of years have supported the position that the legislature should abolish the sentence of life without the possibility of parole for anyone who's under the age of 18 that's convicted of a crime that carries that sanction. And we would recommend that the legislature adopt the possibility for basically establish a life sentence with the possibility of release in those situations, and that the eligibility for release be 25 years rather than 30 years. The 30-year eligibility sanction that you've been hearing about, that applies to any adult that's sentenced to life with the possibility of release. There are certain categories of first-degree murder that's where the sanction is. For example, committing an aggravated robbery and killing somebody in the course of that. That's first-degree murder. It carries a life in prison mandatory sentence with the possibility of release after 30 years if you're an adult. We do believe that juveniles are, fundamentally different than adults, and that's why our recommendation is that that review decision be made after 25 years rather than 30 years for a juvenile convicted of these crimes. And just so you keep in mind, you heard about the 8 cases from Professor Moriarty. These are cases of juveniles sentenced to life without the possibility of release. There are a number of other cases where juveniles in our state have been sentenced to life in prison with the possibility of release after 30 years. So the list is longer than just these 8 of juveniles that are serving life in prison. And again, these are the most serious and heinous crimes that we have in our state. Your legislative body here has the authority to make the decisions as to what the sentences should be, and we support a mandatory life sentence in those cases, whether you're an adult or a juvenile. But as I said, for juveniles, if you're convicted of a crime that carries a life in prison sanction, it should be with the possibility of release after 25 years. That's the position of our County Attorneys Association, and that's consistent with the recommendations of the report that you've heard. I want to thank Representative O'Neill for her leadership, and the other representatives that participated and senators that participated in this commission. This is an issue that needs to be addressed. We should not leave an unconstitutional law on the books in Minnesota. So I would urge you to make a decision and move forward in connection with this issue, because we should get this resolved and put into law. And you are the policymaker, as Judge Guerin says, and we should establish a law that's consistent with the United States Supreme Court's decision. So thank you for the opportunity to testify today, and if you have any questions, I'll be happy to answer them.
Representative O'Neill.
Thank you, Mr. Chair. Thank you, Mr. Backstrom, for being here today, and I appreciate your wisdom on the council, on the commission. We had a lot of conversations. I didn't realize it was 7 full 2.5-hour meetings, but I felt the weight of it after about the 6th one. It was very, very heavy and very weighted, and we certainly delved into deep discussions about all the different aspects. What I found most interesting, and maybe you could speak to this as well, because it might be most surprising coming from you, considering your hard stance on crime, and we all know that very well and respect that. But as we were debating and discussing and kind of finalizing the report to bring to the legislature, we kind of did a test of the room to see the appetite of all of the spectrum of folks at the table, whether they would be in favor or not of the Miller factors. And I found your comment about that incredibly interesting. If I recall correctly, and correct me if I'm wrong, I believe that you said it would be so expensive and so cumbersome here in Minnesota to follow the Miller factors that prosecution would be incredibly challenging, and it would be a dueling back and forth of psychologists and psychiatrists. Can you just speak to that for just one moment, please?
Well, thank you, Mr. Chair. Representative O'Neill. Yes, I did make comments along the lines as you mentioned, and I do believe that if the legislature were to adopt a law that incorporates the Miller factors, that we would have extensive litigation in these types of cases over whether or not those factors are applicable. And with many expert witnesses, it would be very expensive to litigate these types of issues, as we would if that's the decision of the legislature to do. But our recommendation, as I mentioned, is to just eliminate life without parole, create a life in prison sanction for juvenile offenders convicted of first-degree murder, and have the eligibility for release after 25 years rather than 30. So that would be much less litigious in our view.
Mr. Chair.
Representative O'Neill.
Thank you, Mr. Chair. Thank you for conveying that to the committee, Mr. Backstrom. Also, can you just give us just a little bit more meat and background as to how the county attorneys arrived at 25 years versus 30? And I was made aware recently the life expectancy of a juvenile sentenced to life in prison is at 51 years old, I believe I was told. And Perry Moriarty is shaking her head yes. So maybe that's where I heard that. But what did that weigh into your decision to go to 25 years at the first look of possibility of release, given that the life expectancy of a juvenile being sentenced to prison is 51 years?
Well, thank you, Mr. Chair, Representative O'Neill. The county attorneys have discussed, and I'm talking about the County Attorneys Association, our board of directors, which is about 23 or 25 members of our elected county attorneys across our state, and a few deputy county attorneys that sit on our board. But we've discussed this at length for a number of years. We've reviewed, and I've been involved with dealing with juvenile justice issues for many, many years. I co-chair the Juvenile Justice Committee for the National District Attorneys Association for over 15 years. And we've discussed these issues, both at our state level and at our national level. And yes, I have, and my colleagues have reached the conclusion that there is a fundamental difference between adults and juveniles in terms of their brain development. And that's the reason why the United States Supreme Court came down with the decision it did. But in terms of the number of years, we have to keep in mind that the crimes we're talking about are the most heinous crimes that occur in our state, the most serious crimes, the premeditated murder of another human being, and in some cases, multiple human beings. These are crimes, and I do believe that clearly 16 and 17-year-old adults have a different, they understand right from wrong, and they understand it's wrong to kill someone. And this isn't a question about whether they should be held accountable. Yes, they should be held accountable as adults for committing these most heinous crimes. But in recognition that their brains may not have been fully developed at that age, we would recommend a lesser sanction than the 30 years that applies to adults for the review for possibility of release. And again, these are all individual factors. You have to look at the individual case. You have to look at the facts that are involved in these cases. You have to look at the individual person that is convicted of committing these crimes. And, all of these factors that are, we still look at those, and those will be considered by the Commissioner of Corrections or a parole board if the legislature chooses to change the way that those cases are reviewed for release. But we believe 25 years is appropriate and needed in terms of the level of sanction for this type of a heinous offense that the juvenile would be convicted of. And listen, there may be differences of opinion on that, but all I'm telling you is the county attorneys believe that 25 years is the appropriate length before, it should be a life sanction with review after 25 years, and that's our belief.
Thank you. Representative Ward.
Thank you, Mr. Chair. And Mr. Backstrom, thank you for coming, and I appreciate all of the work that the commission has done. And I may be jumping way ahead, but I'm wondering if any of you know of any research that's been done, and maybe Pennsylvania is a better example because they have more people to deal with. But if children are sentenced, as we've been discussing, 30 years later, or even 25 years later, when they've spent more than half of their time incarcerated and hopefully getting treatment and programming, what is their ability to function on the outside? I'm thinking about brain development and the kinds of lives that they end up living and growing up in. Is there any research? Has anybody looked at when we do this evaluation after 25 or 30 years or 40 years or whatever it ends up being, is there any indication anywhere that we've really been able to help some people and help them be productive members of society?
Mr. Beck?
Mr. Chair, Representative, I'm not the person to ask that question of, because I don't know the answer to that question, but it's certainly a good question and something that the psychologists that deal with these individuals would really have to address. And they are reviewed. And as you probably well know, when someone is in our prison system, Minnesota's prison system is very good in terms of the opportunities given to offenders who have been incarcerated in terms of development and addressing mental health needs and addressing educational opportunities and growth potential. So there's a lot of opportunities for people who are incarcerated. But again, when we're talking about these types of heinous crimes that have been convicted, there needs to be a significant sanction. So thank you for the opportunity to testify, and I'll invite Justice Anderson up if there aren't any further questions of me.
Thank you. Justice Anderson, if you could introduce yourself and begin.
Chair, members of the committee, I used to be somebody, not so much anymore, but I served on the committee. If you would look at me as a piece of grammar and punctuation, look at me as an exclamation mark today. And I am an exclamation mark behind the statement that you need to do something, okay? I am not going to be so bold or naive as to say that in a completely objective standard, you are compelled to do something. That is not, because you are not in that sense. But you should be doing something, because inaction will speak volumes about who you are as a legislature and who we are as a state. Now, in this age of fake news, distortions, whatever, we seldom get faced with some things that are absolute truths. But there are some absolute truths involved here. One, Minnesota has on its books laws that are unconstitutional. No question. And those laws are the product of this body as signed by the governor. Minnesota is one of 8 states that remains that leaves these unconstitutional laws on the books. And another truth, and I want to say, this is not an ideological issue. Most people will agree that our current Supreme Court is a conservatively oriented Supreme Court. But that court, interpreting our most fundamental law, the United States Constitution, has said that what you have on the books is unconstitutional and violates that fundamental law. Second, or third, basically, is that each and every one of you has taken an oath to support the Constitution, both the United States Constitution and the Minnesota Constitution. So you have a sworn duty to act. And you should infuse that with the idea that you have a duty to timely act when you become aware of something that you have done or your predecessors have done violates some of our most fundamental law. Now, we have another issue here that is key to what I used to do for 2 decades, the concept of separation of powers, okay? I have written on where mercy and compassion can be within the prerogative of the judge or the justice. Forgiveness is not. That is a bigger societal issue that is determined by policy and who are the policy makers in our society. Oh, yeah, judges do it sometimes when we have to. But the main policy makers in our society are our elected representatives and the governor. That's you. It's right at your doorstep. And I'm going to tell you that courts will make a decision when we are forced to by an issue. I mean, we don't like to. You should be back in our conference room and we say, why didn't they do something? Or they could have done something. Why? And so inaction often speaks loudly about who we are as a state and who you are as a body. So I think a legitimate question can be asked by any of your constituencies, Madam Representative, Mr. Representative, we do have on the books something that is unconstitutional. Why have you chosen not to act? And so, well, you're not compelled to act. I think you have an absolute duty to act, and please do so. I'm not going to speak to the various alternatives you have in front of you, other than say a couple of things. One, don't let your own vision of what is perfect be the enemy of the good. That sometimes happens. And is that what this body is structured to do is to seek the common good. And so don't let yourself get blinded by your own view of what you see as the perfect good. Work with each other in trying to figure it out. I would hope that you infuse your decision with certain things. One, do it with an understanding of the human condition. I'm going to address, I think, Representative Ward's question about what happens when people are in prison for a long time. But do it with an understanding of the human condition and that there is a place for actually reform and forgiveness in our society. And another thing, some of you know I was on the Capital Restoration Commission, and I've given a lecture about the dead hand of the architect, the artist, the judge, and the legislature. We are often formed by the dead hand of what you do today. Lawyers will be guided in the future by what I did before. But I would ask that you be aware of this concept and not try to make that dead hand too controlling. Have a little confidence in future generations so they realize that they can deal with and handle some of these problems as they evolve. It was surreal for me to see these cases reviewed today because I know each of them rather intimately. Some of them I wrote the decisions about, and some I dissented on, wrote extensively on. There's just something very true about the people that come into our system of justice and do some very bad things, heinous crimes. Most of them are not evil. Most of them do bad things. They do stupid things. They get into bad situations. Some of those up there, I will say, yes, I think there may be one or two that because of their makeup, they're evil, but most are not truly evil, but they do bad things. And there is room in the system, especially when you're a juvenile, for reform. One of the things I say about myself, be careful because I'm very dangerous with a little bit of knowledge. And in answer to your question, Representative Ward, it's all over the spectrum because I do follow the lives of some of those people who I have a direct effect on. Some will do well. Some have done well in prison. They've taken advantage of the others. Some have actually withdrawn and become, I would think, worse persons as a result of this process than they were before they went in. It's all across the board. But put in your system a method to accommodate that whole broad spectrum because there are no absolutes. Finally, like some of you don't want to be here today, and I don't want to be here today. I have a strong respect for separation of powers. I'm aware of my former position. I don't like appearing before you, but I'm here for basically one reason. The reason some of you are here, Representative O'Neill. Some were surprised about my support for my colleague David Strauss for his appointment to the 8th Circuit. David and I disagree on much about the law and how it gets implemented. But we agree on the fundamental concept of how the system works and what must be done to make it work well. You should appreciate what Representative O'Neill has done. She and I, if we were put in a room and asked to decide different things of policy, we would disagree on a lot. But we do have a fundamental agreement on how our system of democracy needs to work. And she has brought this matter to you and put it for you because she's asking you basically do the right thing. And as Martin Luther King once said, the time to do the right thing is always now. So do what you need to do. That's my exclamation point. Any questions?
Representative Dean? No. Oh, Representative Hilstrom?
Thank you, Mr. Chair, and thank you, Your Honor, for being here.
Oh, by the way, can I say one more thing?
Yeah.
It is a pleasure for Jim Backstrom and me to sit here and be on the same side of an issue. You know, he's got a good heart, and I appreciate his comments.
So, Justice Anderson, I'm actually going to pose a hypothetical to you because you're not on the bench anymore. You can actually maybe answer it. But could you tell us, if we actually adopted what Mr. Backstrom is asking, 25 years, and did, as you said, the right thing, what would happen to these cases, or what would likely happen to these cases that have already been corrected, where they have said life with release at 30 years? What would you anticipate would be the next step for those cases?
Are you a lawyer?
I am.
Judges hate hypothetical questions.
I know that. That's why I asked.
And you know that, and you're putting me on the spot. And so judges are very practiced at avoiding the full spectrum. I think that the cases we have now that we're up here, I mean, they're moving along, and there's, yes, I mean, I would disagree with Mr. Backstrom on one thing. He said, I says our prison system does it well. No, we're a cut above. So it's a comparative that he's just, Backstrom is talking. We do it very well compared to others. I think there are a lot of deficiencies, and I'm on the record of that. But I think it works well. There is a lot of weight on the commissioner, but I think you need to have some system where, I mean, this is a fail-safe. We're all human. We all make mistakes. And I think there needs to be some entity that will review the condition of an incarcerated person, whether it's 25 years or 30 years. And so let it start kind of administratively with the commissioner, and then if there's dispute, let it go to a panel that will make that decision. And the devil's in the detail of who is part of that panel, but I think that would work.
Mr. Chair.
Oh, by the way, he's right. There will be a lot of litigation. Maybe not as much as he anticipates, but then, hey, that's how our system works sometimes.
Mr. Chair.
Representative Hilstrom?
Thank you, Mr. Chair. So then, would you think that we should make, if we were to adopt a 25 years retroactive to apply to these 8 cases that have gotten life with 30 years? Or how would you, I'm just trying to figure out how any change that we make would impact the cases that have already been relitigated, not the 3 that are still yet to be determined, but these other 5 cases.
I have a bias on retroactively applying these things because I have actually written on that issue. When it first came up to the court, I said that the law applied retroactively. I was in the minority on our court. The Supreme Court subsequently said that no, it is retroactive. I believe that it is retroactive. But understand, I come from a particular point of view on it. I think it should be retroactive. But that's a policy decision that's going to be worked out by you in context of what the big guys up on the Supreme Court say.
Thank you.
Representative Dean?
Thank you, Mr. Chair, and this could be to you, Justice Anderson, or
Oh, by the way, sir, you did the right thing on the state office building if you were going to ask me about
no,
that.
no, I wasn't.
I served with the
You mean the
representative
Senate
on
office
design
building?
build.
You mean the Senate office building? We
Yeah, the
didn't.
Senate
yeah,
office
yeah,
building,
yeah,
yeah.
yeah. Well, they're enjoying it, right?
Yeah, I know they are. Both parties, both parties.
Yeah. So, I mean, when I'm considering this, I have a lens. We all have a lens that we look through, and one thing I try to do is really separate my lens from what is right, because I think they're not equally the same. And I think our job here is first and foremost public safety. And that's a hard thing to speak to when we're talking about heinous crimes, because the public perceives them as very different. I think the victims of those crimes also perceive these crimes very different because they've been personally impacted. So there's a component of penalty, retribution, and all those other types of things that oftentimes don't have anything to do with the issue of public safety. So when I think about this and I hear about 25, 30, all those types of things, I think about the individuals that actually serve time. So if I serve 30 years and I come out, am I a lot safer than if I had to serve 25 years and come out? I mean, those are the types of things that I try to consider. And, you know, I'm glad you brought up, you know, Minnesota does it right in our corrections, because I don't think we do. I think over the past decade, we've reduced a lot of the programming for inmates inside. I think fortunately, we have begun to increase the amount of funding for chemical dependency treatment and other types of treatment for individuals that are locked up inside. So we're getting some of that back, but we still have a long, long ways to go. And I guess why I bring this up is I think this is a real complex question. And when I think about the young brain in its development, you know, a comment was made that 16, 17, they know the difference between right and wrong. When they kill somebody, they know that's wrong. Well, they might know it's wrong, but they don't understand the consequence of that. And I think that that's a key piece in all of this conversation. We've learned so much more about brain development and what happens. And, you know, I mean, I can only speak for myself. I did things at the age of 15, 16, 17, 18 that I would not do today. And I'm one of the few people in our legislature that spent several years behind bars. So I think that the issue of public safety, I think, should always be in our forefront in what we're thinking about, while still considering the victims that have been impacted and the severity of crime, if that makes any sense at all.
Well, that makes eminent sense, and each society makes that decision on its own. I mean, you are familiar with the gentleman in Norway who killed 67 people on the island. I mean, he's eligible for parole right now. In the Norwegian system, they say that you can do that. He won't get parole. And if you look at the studies on incarceration, most of the benefit of incarceration as far as having an impact on the offender occurs within the first few years of the incarceration. The latter years are dead time, basically, and you try to do some reform, whatever, but it's not helping reform. If you look at first-degree murder offenders, they have one of the better records of non-reoffending, and so what you come down to is the societal decision of what is the penalty that is going to be paid by someone who's done something bad. I mean, no mistake here. Somebody has taken the life of another human being, and there is a terrible permanence to that event when somebody is removed from this earth. And so we have as a society decided, I mean, we've got all these other factors in here, but when you do something that heinous in the context, you are going to be separated from society for a period of time, whether you are a danger to society or not. So the question is, I mean, what do you make as a decision as to the penalty in society for a very bad crime? And then the key decision will be what happens when the period of time ends, when somebody is paid what you deem to be the proper payback for a bad act and coming back into society as a fully reevaluated and full citizen. That is a key question. I hate to bring up the Drew Schradeen case, but this was an offender. I mean, even his family said, don't put him back into society because he has problems and he is dangerous. So what you need to think about is not that one solution fits all. You have to have a system that will understand that some people are fully rehabilitated, some marginally rehabilitated, and some, by something inherent in them and in their minds, they still may be a danger to society. But don't try to make one mold fit everybody, because again, I go back to understand the human condition, and don't try to overly exercise your dead head as an architect of what's going to happen 25, 30 years from now.
Representative Considine? Representative Lomer?
Thank you, Mr. Chair. And I just want to thank you and everyone for this meeting this morning. This has just been really fantastic. I actually am working on some legislation. I had a gentleman from Washington, D.C. contact me, and we've been working through this, and I'm excited to bring this forward and hope we can have a hearing about this because I think it's really important. And I guess I just was really, in talking about this, yes, you're right, you know, people that commit these heinous crimes, there needs to be consequences, but there also, it seems to me, really needs to be hope. It's all about hope that they can have redemption, that they can have their life restored. And if you have a situation where you never have a chance, how do you ever have hope? So I like the idea of 25 years. I guess we'll talk about that, but, you know, just to relook. But I think, you know, everyone needs to have hope. And so, thank
May I
you.
address that concept? There's a scholar who writes about the hopefulness of uncertainty. And I think that you need to build some uncertainty in the system such that there can be the hopefulness that if I do the right thing, I reform. There is something I can do to change my future. I may get out. See, that's what the hopefulness of uncertainty is. If the future is uncertain, that means you have some ability to affect the future. So I very much love what you're talking about, the kind of hope, but build some uncertainty into the system so that things can happen in the future with respect to the people who are incarcerated.
Representative O'Neill?
Thank you, Mr. Chair. And Mr. Chair, I just want to thank you too for allowing the commission to come up and do the presentation. And you can see now that there was, after 7 meetings, there was a lot discussed. We had fantastic people at the table from wide variety of opinions, as the justice was saying. Jim Backstrom and Paul Anderson probably different sides of the spectrum. But the one thing that I think that hasn't been said as clearly is back to the Miller factors. I just want to say that, you know, I have a fundamental issue with at age 16, 15, 16, 17, declaring somebody irredeemable. And I'm just not comfortable doing that. So I think that needs to be part of the conversation as we move this forward, that if we decide to implement the Miller factors, in addition to what Jim Backstrom has already said, that they're expensive, they're cumbersome, there's a lot of litigation, which, you know, we can legislate that. I mean, that's a possibility. But I think the greater philosophical question is, do we want to declare somebody at that age as irredeemable, that they are never going to change, and make that determination? That's essentially what Miller Factors is doing. It's making that determination that, yes, we can sentence them to life. They are never going to change. They're never going to reform. They're never going to have hope. And I'm just not comfortable as a legislator declaring that over someone's life. So I would prefer, I appreciate our vice chair having a bill coming forward that looks at, you know, a determination of the life sentence for a juvenile being slightly different than an adult for the very factors that were discussed here. But I think that we should have that conversation. But I just wanted to be clear as to what we're actually saying with the Miller factors. So get that on the record, and as we move this forward, I hope we do have a hearing with Representative Lomer's bill and have that conversation. Thank you.
Thank you. Mr. Chair, may I make one thing to amend the record? I have been informed that I was like a bulldozer over your protocol. I should have answered questions saying, Mr. Chair and Representative. So the error was inadvertent, and that the record can be corrected.
Thank you.
Thank you.
Mr. Chair.
Representative O'Neill?
Thank you, Mr. Chair. Just one final comment. I think that we can give the former justice some latitudes. But it's great to have him here. It was great to have him part of the commission, and he has great wisdom. So at least for my part, I felt it was okay for this one instance, but thank you.
I just came back up in case there were any more questions, but other than that, we'd really thank you very much for listening to us. We appreciate it very much.
I want to thank you, all the people that work on this committee. It's, as those of you who hadn't been listening here today, you can see it's a very complex issue, and I think there's still a lot of unknowns that we have to deal with. But that's something, as the judge or the justice said, It's the policy issue that we have to make. So thank you.
All right, thank you very much.
That will conclude the meeting. We are adjourned.
Okay.